All right, thanks guys. So I'm Paul Gugliuzza from Boston University School of Law. So I'm going to talk about a paper titled Invalid Patents. So this paper it's definitely a work in progress, and I welcome really all types of questions, comments, and suggestions. So let me start by just providing sort of the 30,000-foot overview of this piece. So as we all probably know, the patent system has undergone some dramatic changes in the past 5 years. Traditionally, disputes over patent validity occurred mostly in court, in the course of patent infringement litigation. But thanks to the American Invents Act, we've seen a substantial increase in the number of disputes over patent validity that are instead being resolved in administrative proceedings at the Patent and Trademark Office. So at first glance, this migration of patent disputes from the courts to the PTO would seem to be a positive development. Right? Patent litigation in court is expensive, proceedings at the PTO are cheap, they're designed to conclude relatively quickly. However, most patents being reviewed at the PTO are also involved in litigation proceedings between the same parties. And if you have concurrent proceedings, both at the PTO and in the courts, that sort of threatens to negate the advantages of administrative review of patent validity. Moreover, concurrent proceedings to evaluate the validity of a single patent present really tricky questions about how those two proceedings relate to one another. Most notably, what happens if a court rejects a challenge to a patent's validity and awards damages for infringement, but the PTO at roughly the same time finds the same patent to be invalid? It's an important question. The Federal Circuit's decided 3 contentious and controversial cases on this issue in the past 2 years, and as the PTO becomes more and more popular, I think we'll see conflicting decisions occur more often. But there's not really any academic articles exploring the implications of conflicting court and PTO decisions on the validity of a single patent. Part of the reason, having now sort of written that article, I suspect that is because these cases are really, really complex. And so a big chunk of the paper is a deep dive into those cases, and I'll give you just a little taste of that in a moment. But before I do that, sort of the 2 main normative takeaways of the paper. First, the best option, or maybe the most effective option for courts to avoid conflict with the PTO is to simply stay litigation pending PTO review, although that's by no means a perfect option for reasons I'll talk about a little bit later. And then second, unlike the Congress, unlike the courts, is well situated to fully solve this problem, since it's a problem that Congress created when it created these parallel proceedings. Abolishing parallel proceedings would obviously solve the problem, but that's a bad idea from a policy perspective and so politically unrealistic also. A more realistic option for legislative reform stems from the fact that the courts and the PTO currently apply different legal standards when evaluating patent validity and construing patent claims. And if the law on those questions were harmonized, I think we'd see a reduction in the number of conflicting decisions. Okay. So the time I have left, let me do a couple of things. One, I want to talk about some of the key cases the paper is structured around, because I think they'll sort of illuminate these issues that I'm talking about. And then second, I want to sketch some sort of normative thoughts in more detail as a springboard to Q&A. Okay, so the leading Federal Circuit case involving conflicting decisions between a court and the PTO is Fresenius versus Baxter, a case that was decided by the Federal Circuit in 2013. The infringement litigation there actually began 10 years earlier. Baxter asserted 3 patents. The district court ruled that all 3 patents were valid and infringed. It awarded Baxter about $14 million in past damages, and it entered an injunction, and it awarded Baxter some ongoing royalties. On appeal, the Federal Circuit affirmed the judgment to Baxter on the claim of infringement, but it vacated the injunction and the ongoing royalties and remanded for the district court to reconsider just those remedial issues. So at that point, the court proceedings on validity, infringement, and the amount of past damages were effectively concluded in Baxter's favor. So then on remand, the district court eventually resolves the remedial issues remaining in the case, enters a final judgment, which Fresenius again appealed to the Federal Circuit. Okay. At the same time that all of that was going on in court, Baxter was also defending the patent's validity at the PTO in a re-examination that Fresenius, the infringement defendant, had requested. Ultimately, the PTO invalidated the patent claims that Baxter was asserting against Fresenius in the infringement litigation, And while Fresenius' second appeal in that infringement litigation was pending, the Federal Circuit affirmed the PTO's decision to invalidate Baxter's patents. And then, once the Federal Circuit got around to deciding that second appeal of the infringement litigation, the Federal Circuit vacated the damages judgment in Baxter's favor because of the PTO's invalidation of Baxter's asserted patent claims. The Federal Circuit's basic reasoning was that its prior opinion resolving the issues of validity and infringement was not final because it left open questions about Baxter's remedy, and therefore the PTO decision could wipe out the damage award that Baxter had obtained, the award of past damages that Baxter had obtained. But here's the problem, right? Fresenius, who is the accused infringer, had a full and fair opportunity to litigate the issues of validity and infringement in the court case. In fact, it went all the way to the Supreme Court with a cert petition on those issues after the Federal Circuit decided the first appeal. And it lost. Yet, the Federal Circuit's decision basically gave Fresenius a second chance to invalidate the patent by relying on the subsequent PTO decision and re-examination. So maybe that's getting sort of two chances to prove invalidity seems a little bit unfair. Right? But remember that if Baxter had won, it would be collecting $14 million in damages for infringement of a patent that the PTO has definitively held to be invalid. Okay? So right away, I hope you see there's not really an easy answer in these cases. Okay? There are two other recent cases that extend and clarify the Federal Circuit's approach to conflicting decisions between the courts and the PTO. One called Sada versus SAP, and another one called Ipsc versus Lawson, which is a case in which the court recently denied rehearing a bank by a vote to 5-5. For now, let me just focus on Versada because I think it provides a nice contrast to the Fresenius versus Baxter case that I just discussed. Okay, so in Versada, Versada was the patent holder. It won an infringement judgment of about $400 million in the district courts. Much like in Fresenius, the rulings of validity and infringement were affirmed by the Federal Circuit on appeal, but the Federal Circuit remanded so the district court could revise the injunction. While that was happening, while the remand was happening, the PTO invalidated Versada's patent in a covered business method proceeding that SAP, the accused infringer, had instituted. Back in the district court on remand, Versada abandoned its claim for injunctive relief, which would resolve the last open issue that was in the case. So the district court entered a final judgment. SAP, the infringer, appealed to the Federal Circuit, pointing out that the PTO in the CBM proceeding had already invalidated Versada's asserted patent claims. Right? But in that case, the Federal Circuit affirmed the district court judgment, allowing to stand the $400 million damages award for infringement of patent claims that had been canceled by the PTO. The Federal Circuit's opinion doesn't offer any reasoning at all, which is itself sort of indefensible, but the seeming justification for the different results in the two cases is that in the Versada case, the PTO decision canceling the patent claims had not yet been reviewed by the Federal Circuit. So the PTO's decision wasn't sufficiently final to wipe out the court award of damages. Okay. So as I said, right, lots of sort of complexity, messy procedural details. Let me sort of offer a few normative thoughts I think will summarize the state of the law today and hopefully provide a springboard to Q&A. To begin with, these cases illustrate that it's really not an easy task for the Federal Circuit to balance the authority of two different government bodies that possess independent power to invalidate the same patent. And the rule the Federal Circuit has developed has the advantage of providing a bright line. Right? It's what I call in the paper sort of absolute finality. Right? When you've got two parallel proceedings in the courts and in the PTO, it's simply a race to the finish line. The first proceeding to reach a final, irrevocable resolution after all appeals will control. But there's also a lot to dislike about the absolute finality rule. Among other things, it's inconsistent with the flexibility and pragmatism with which the law usually addresses the problem of repeat adjudication, most notably through the doctrine of issue preclusion. The absolute finality rule raises some separation of powers concerns because it allows the PTO to effectively override decisions of Article III courts. It deters settlement and encourages losing parties to prolong litigation while seeking a favorable decision from the PTO. And it just seems unfair and inefficient, right, to allow accused infringers multiple opportunities to defeat liability. So one question my paper asks is whether the courts can develop a better alternative to the absolute finality. The most plausible alternative would be that a court decision is final not when the case is completely concluded, as the Federal Circuit has held, but whenever the issue of validity is fully resolved by the court, which might occur much earlier in the case because you may still have some remedial type issues to be resolved later. If you're familiar with any of these cases, Judge O'Malley and Judge Newman have sort of urged this approach in some dissents. The problem with that approach is that deeming a court decision to be final earlier in the case might result in even more conflicting decisions. Why? Well, one redeeming quality of the absolute finality rule is that because it allows PTO decisions to wipe out court judgments at a very late stage in the case, it sort of incentivizes district courts to simply stay litigation pending review at the PTO, which is probably the most effective way to avoid conflicts between the courts and the PTO. And if court decisions became final and therefore immune from the effects of PTO review earlier in the case, right, courts I think would be less inclined to stay their proceedings. Right? So as I said, right, I'm not sure there's an ideal option for the courts to resolve for the courts in resolving these cases involving parallel proceedings and conflicting decisions. But Congress could step in and really make do some things that would help solve this problem. The most obvious solution is to simply abolish parallel proceedings, right? Shift all proceedings to the courts. But I think that's really unlikely, given the trend for Congress to increase the role of the PTO in resolving patent disputes, not to reduce or eliminate it. More promising might be a regime of what you might think of, and Greg has talked about this a little bit in some of his scholarship, staged adjudication, which in this setting might involve, say, the PTO first resolving all issues of validity, then the courts tackling the issue of infringement. This would also be similar to models we see in countries like Germany and Japan. But this would be a pretty radical change, right? Also, the courts need some flexibility, as we're increasingly seeing cases raising Section 101 issues. Sometimes the most efficient way to resolve a patent dispute is to simply have the court grant a motion to dismiss for failure to state a claim. And we shouldn't take that option off the table. So I'm not sure, sort of mandatory staged litigation is a great solution as well. One small step towards harmonizing decisions by the courts and the PTO would be to require that they each apply the same legal standards when evaluating patent validity. Right? Under current law, an accused infringer in court has to prove invalidity by clear and convincing evidence, but the burden of proof at the PTO is preponderance of the evidence. Likewise, courts interpret patent claims under the ordinary meaning standard of Phillips, while the PTO gives claims their broadest reasonable construction. I think if you align the standards for evaluating patent validity, that may reduce the number of conflicting decisions as a practical matter. And in addition, aligning the law would in some circumstances, I think, entitle court rulings to preclusive effect of the PTO and vice versa under the Supreme Court's recent decision in DMD hardware. Right? In that case, the court held that a PTO finding of likelihood of confusion during trademark registration could preclude relitigation of that issue in a subsequent infringement case, right? On the patent side, we don't get that sort of court agency preclusion, largely because of the different legal standards that apply in each of those proceedings. So I think all these observations lend support to some proposals that are sort of percolating in Congress to align the standards, particularly of claim construction, but also in some proposals to align the burdens of proof on validity. All right, so there's more I could say, but I'm just going to stop there because I would love to hear your questions about this.
I'm really excited about this project. Couple of interesting things. So first of all, we have a version of this at the ITC with invalidity and the like. And there's one crazy decision where the Federal Circuit affirmed the ITC's finding that a patent was invalid, and then affirmed the district court's finding that the same patent was valid. And so there's no contradiction in this, that it's valid in one instance, it's invalid in the other because two different statutes. And you have a similar dynamic here because you have different standards with what the PTO does and what the Federal Circuit does. But your argument's going to be more compelling because, first of all, I can only come up with one weird ITC case where that happened, and this is going to happen a lot more frequently. And second, this is the same patent. This is all under the Patent Act. It's not, agency acting under trade law. It's all one thing. So one thing you may want to look at is you've got weird administrative law issues creeping up here, because usually the situation is the agency is charged with administering the statute, and even if the court comes first and, say, interprets it or the like, the agency is free to disagree and use its own authority. Here, you've got the very weak PTO that lacks substantive rulemaking authority, and so it raises interesting questions. Does that change our usual dynamic, such that maybe the PTO shouldn't have their own say in it, or I have no idea what the answer is, but I'd love to see, love to hear your thoughts and see the paper when it's ready.
Yeah, definitely. Well, so a couple of things. One, first of all, you're absolutely right. You see this in the the court ITC context, and your article, your Florida Law Review article, in fact, has been very helpful to me in sort of in the paper, talking about how this also comes up in the ITC in a similar but also different context. And then second, you're absolutely right that this occurs more often in the court PTO context. And in fact, an earlier Federal Circuit decision in the involving that Baxter patent was exactly this setting, where the court had in the first appeal of the infringement litigation had affirmed the district court's ruling of validity, but then on appeal of the PTO reexamination, they affirmed the PTO's decision invalidating the patent, right? So they engage this issue and they say, well, because we apply different standards, because the PTO and the courts apply different standards, we can have differing results, right? So maybe that's somewhat of the analog to administrative law. Whether that's a convincing analog, I'm not sure. I think it just sort of takes me back to this notion that it is a little, even if we can say the law is different, right, because of the burdens of proof and standards of claim construction, at the end of the day, the courts of the PTO are trying to answer the same question, which is, does this patent application or this patent itself satisfy the legal requirements of the Patent Act? And it's a little bit weird that you can get a different answer to that question just because of these sort of other principles of law that have been grafted onto the different institutions we have. Great.
And this is actually following up on what you just said. So I think there's a need to distinguish between the doctrinal and the normative questions here. Because I don't really see much problem in the current situation under basic, unless we're going to go with a patent exceptionalist approach to preclusion. There's no real doctrinal problem under preclusion rules. Courts do not find patents valid. They just find them not invalid. It's a different issue. There's no preclusive effect to the resolution of a different issue. The basic idea that as long as a case remains open, intervening changes can allow you to undo what was previously done. All of that is basic doctrinal accepted doctrine. And it's just a matter of, should we have an exceptionalist approach in patent law? So that raises the normative question, right? And I think that's a more interesting question, because redoing or undoing a $400 million judgment might be inefficient, right? But that raises a real question of who should be deciding these. And there's two different approaches. One is the patent office should be deciding these issues, which would be automatic stay of litigation. And the other is district courts should at least have equal power to resolve these issues, which is where your proposals are going to go. It would sound like they're going to go, because it would be a preclusive effect of the district court or the PTO. I guess it would be a race to judgment, essentially. And that, I think, raises questions, and maybe explore these, about things like expertise, who's better at this, efficiency, and then the third one, I think, is also the nature of a patent right. Is a patent right just a recognition of pre-existing property rights, or is a patent a grant of a permissive government right, or something along those lines? And in that case, if it's a grant of a permissive government right, well, the government that issued it is probably the one that should be resolving the issue of whether it should remain or not.
Yeah, no, so I mean, I largely, agree with everything you said. On the doctrinal piece, I think it's not, and I'll talk about this a little more in detail in the paper when I get too bogged down on it here today. The Federal Circuit, the way it presents these cases is as if it has no choice, but that the courts have no choice but to yield to the PTO any time the PTO invalidates the patent before the litigation is concluded, right? I'm not sure that's totally true, right? I mean, so the relevant doctrine here, which the court, this is sort of the doctrinal critique, the court doesn't talk about is law of the case doctrine, right? You're absolutely right. Under the law of the case doctrine, the court will have the discretion to depart from its prior ruling here of validity, if you want to call it that, any time before the litigation is concluded, right? But that's sort of a discretionary, holistic, equitable analysis, right? Where we can take into account all of these various normative and policy considerations, 2 bites at the apple versus whatever else it might be, and the court doesn't engage any of that at all, right? It just says, oh no, it's canceled, it's done, right? It wipes out the infringement claim. We've got no choice. We have to dismiss. And I'd like to bring in, if you frame this as law of the case, I think you can bring in more of those interesting policy considerations that I think you're talking about in sort of your normative comments. Almost out of time, Peter. You had your hand up.
You were before me.
Oh.
Yeah, I mean, so I just have a quick question. I guess my thought is that maybe this isn't a new problem with respect to post-issuance proceedings. If a patent holder obtained a judgment against somebody and that judgment becomes final and let's say years go by and there's another litigation in federal court and the patent gets invalidated, it's not like the infringer from the first litigation gets to get their money back, right? So like to a certain extent, like we've already kind of had this absolute finality rule, and I'm just wondering whether you think that that's part of the same problem or whether it's
No,
different.
so I mean, at least the court would treat it as a little differently, right? When the if the judgment is truly final, right? Even in a case like Fresenius, the court acknowledges that you can't undo that judgment, right? But what's making this a little bit more new is just the attractiveness of post-issuance review and the fact that you're going to have more invalidity decisions entered by the PTO before that absolute conclusion of the court proceeding.
Thank you very much.